Good afternoon, everyone. Welcome and thank you for joining us. I'm Melissa Negrin-Wiener with Cona Elder Law, joined by Eric Goldberg from the New Jersey Elder Law Center and Goldberg Law Group. And this is probably our, I don't know, maybe 10th time that we're doing this webinar where we talk a little bit about the differences in the laws between New York and New Jersey, which we say, are connected by tunnels and bridges, but as different as can be when it comes to Medicaid regulations and rules. And since there's so much overlap with family members sometimes being in New York and New Jersey, we always think it's a good idea to kind of bring these differences to the forefront. I am a senior partner here at Cona Elder Law. I've been with the firm for about 23 years, practicing solely in the area of elder law and estate planning. And Eric, you want to introduce yourself?
Sure. Eric Goldberg. I'm the founding partner, managing partner of New Jersey Elder Law Center at Goldberg Law Group, certified elder law attorney. And we help people avoid the financial devastation of the high cost of assisted living or nursing home care. And as we'll discuss in a few minutes, Medicaid in New Jersey also covers home care, but not nearly as well as New York does. One of the main differences. So what we do here traditionally, for those of you who haven't joined us yet in this presentation, we used to do this as a scenario-based presentation where we put a scenario out there and then we talk about the differences uh, and open it up to questions. But what we found is that people just tend to have questions, and what we'd rather do is make sure that your questions are answered. So I think how we'll do it today, Melissa, is kind of do Melissa will do a quick overview of New York Medicaid. I'll do a quick overview of New Jersey Medicaid. And feel free to interrupt us. I have the Q&A up. That would be the best way to interrupt us. Just fire away whenever you have questions. If you had any burning questions before this and they're a little off topic, feel free to try us. What tends to happen is we just answer questions the whole time, which is really fun.
Right.
So, let's get started.
All right. So when we talk about Medicaid here in New York, we're primarily talking about home care and nursing home care. As a general rule, Medicaid does not cover assisted living in New York. There's a handful of assisted living facilities that that do take Medicaid, and it's the home care type Medicaid. But again, those are very few and far between. They have waiting lists. So I'm going to really focus more on the home care and the nursing home care. So in New York, in order to qualify for either home care or nursing home care, an individual is allowed to have $31,175 in assets. That's anything that is non-retirement. So that will include, the cash value of life insurance policies, bonds, stock, regular financial accounts, investment accounts. But IRAs and 401ks, 403bs do not count as an asset towards that 31,175. But the income that is kicked off of those accounts, the required minimum distribution, is counted as income. So as long as the distribution is coming out, Medicaid in New York does not count the principal of the retirement account as an asset. So 31,175 is the magic number. And that is, again, for either home care or nursing home care. Many of you are probably familiar with the terminology of the 5-year look back. The 5-year look back in New York does not exist for home care right now. There may be a 2.5-year look back coming down the pike, but as of right now, there is no look back at all for home care in New York. But the 5-year look back is in place for nursing home Medicaid. So when we apply, we do have to provide 5 years of records, bank records, to the Department of Social Services. And they want to know basically what you've done with your assets, typically looking at any transactions of $2,000 or more in or out. And they require explanations and documentation for those. And there may or may not be penalties attached to that, depending on how assets were moved around in the past. And then, of course, we have the the nursing home income rules and the home care income rules, where a person who is getting home care in New York is allowed to keep $1,732 a month of their income. Anything over that would go to a special type of trust that is created. We call it a pooled income trust. I believe New Jersey calls it something different. But it is a trust where any of your excess income will be directed into that trust on a monthly basis, but can still be utilized to pay for your regular monthly expenses. So you're still going to have access to all of your income, and Medicaid is going to determine how many hours of care they are going to provide. Anywhere from 4 hours a day to 12 and 12 split shift. So somebody constantly awake, constantly there would be the highest number of hours somebody will get. That is not a standard thing. People don't get that all the time, but it does come up on occasion. If you're in a nursing home on Medicaid, you get to keep $50 a month of your income. Anything else will go to the nursing home, and Medicaid will pick up the difference. Unless you have a spouse in the community, some of your income may be able to go to the spouse. And I'll talk a little bit more about spouses, Eric, as we go forward, because I know there's some big differences there. So if you want to cover the basics in New Jersey.
Yeah, let me just grab some of these questions. Okay, so someone's just remarking that Melissa's talking too fast. She's actually not really talking too fast. So, but if you think if you're interested in seeing this information again or hearing this information again, this will be recorded. So don't worry about that.
But I'll try to slow down a little.
Yeah, and you're not going to see the screen advance. That's a static screen. We're not going to be using a PowerPoint today. So the question here, there's a question for you. Is there a cost share if you do a pooled trust? But that's not really, well, explain why that's not really relevant.
Well, there's not cost share. Your money that's going into the pooled trust is earmarked for you. So you get your income, the other people get their individual incomes. It's just a pooled account. So it's a way of making more interest on the account and things like that. But it's a pool of money. Your amount is your amount.
Right. Okay. And this individual is saying New Jersey Qualified Income Trust has a cost share. That's not entirely accurate, but I will discuss the Qualified Income Trust when I go through New Jersey. Another question would be any info on MLTC of New York? That's pretty much what you're talking about, right?
Yeah, so, well, an MLTC is a managed long-term care plan. So basically what happens is once the Department of Social Services approves the financial piece of the Medicaid application, then the individual needs to sign up with a managed long-term care plan, and they're the ones who actually provide the assessments, and they determine how many hours of coverage Medicaid is going to pay for, and they of course take into consideration all of the assessments done, including the one that's done initially by New York State, and they determine the number of hours, and they're the middleman. So they provide the care, they do the billing, they contract with the home care agencies who ultimately go into the home.
Okay, so somebody's asking about the spouse. Maybe you can go through the spouse. If one spouse is on Medicaid and the other is still working, can the one who works keep all of his or her income?
Okay, so in New York State, if you have a spouse at home and you're in a nursing home, that spouse is allowed 3,800, and have the exact figure, of course. I'm not committed to memory because it changes every year. $3,853.50. And that's what the spouse in the community is allowed to make. So if the spouse in the community is still working and they make more than that, yes, they can keep it. But in New York, they have to sign something called spousal refusal, which is basically a letter saying they make more than they're allowed, but they're going to keep it because they need it to live on. They're not going to make it available for their spouse. In that case, the spouse in the nursing home will just have to put all of their income towards the nursing home care. So they're not going to give anything to the spouse in the community, but the spouse in the community can keep all of their income. The same thing goes with assets. So I might as well touch on that. The spouse in the community is allowed to have $154,000 in assets. If they have more than that, again, they can keep it as long as they sign spousal refusal. They can keep whatever amount of assets they have. What this does is allows the spouse in the community to keep their assets and income, but it gives the county that's paying the Medicaid bill the right to come back later to seek contribution towards the cost of care from the spouse who had or made too much. That being said, in 23 years, I think I've had that happen. I could count on one hand how many times I've had the county come back. Doesn't mean they won't. You have to be aware that it's a possibility, but it is not something that they are very gung-ho about.
Okay, so this is always confusing to people when we're talking about assets versus income. So it's probably worth addressing this question. If Social Security is over the yearly limit, excuse me, of 31,175, can you take some of that monthly Social Security and put it into a pooled income?
So you really have to separate out your thought process of assets and income. So Social Security is in the income column. So let's look, you have to look at it monthly. So Social Security, pension, IRA distribution, if you're taking the required minimum distribution, Medicaid's going to divide it by 12 and add it to your monthly income. So you have to look at the monthly number. You're allowed to make $1,732 a month. If you make more than that, that's what has to go into the pooled income trust in order for you to qualify. The Social Security income has nothing to do with the $31,175 asset limit. That's a separate animal. So if your $1,732 that you get to keep every month builds up and up and up and up such that your assets are now over $31,175, then you have an issue. But that's not a typical scenario. People are usually spending all of their monthly income, especially if they're at home, you know, they have all of their regular monthly expenses.
Okay, that's a great way to describe it. Oh yeah, I'll talk about New Jersey. But before I talk about what is involved in qualifying in New Jersey, I'll talk about some of the differences. So, for instance, in New Jersey, in order to qualify for Medicaid as a single individual, you can have no more than $2,000, as opposed to New York's 31,175. There is a 5-year or 60-month look back for any sub program, I guess I'll call them, within MLTSS, which is our Medicaid program. So for home care, assisted living, and for nursing home care, they all require a 5-year look back, whereas New York has no look back for home care. And I was actually going to ask Melissa, because we've been doing this for so long, that there was a point, I think it was before COVID, where they had a date that they were going to start the 30-month look back, and then they pushed it because of COVID, and then there was another date after COVID, and now you're saying it's not even on the table anymore?
No, it is. It's on the table. It's actually on the books. The
Oh,
problem, and without getting too into the weeds, the problem was that, first of all, they pushed it because of COVID, because during a public health emergency, you're not allowed to reduce the amount of health coverage that somebody would potentially be getting. So they couldn't do it during the public health emergency. Once the public health emergency was over, there were funds that were still in the Medicaid coffers from the public health emergency that had to be used before they could actually make an effective date. So they're anticipating mid-2025 as the effective date. However, there's been so much time now for the elder law bar and other organizations to lobby to leave home care alone. that we are still hopeful that that might be the case. I'll probably know more in January after the New York State Bar Association annual meeting in the city. We get the kind of the word from Department of Health at that point.
Okay. So to continue with New Jersey qualification criteria, there is this $2,000 asset limit, and there are two major criteria. Same with New Jersey. There's the clinical eligibility criteria, which I don't think Melissa touched on. I'm not sure if you did, where the individual must need at least assistance with at least three activities of daily living, or be cognitively impaired to the point where they can no longer live on their own. And then there's the financial criteria, which is what elder law attorneys handle, which is the $2,000 asset limit, and there's an income limit in New Jersey. New Jersey is known as an income cap state, and the income cap is $2,829 a month. Up until maybe 8 years ago, if an individual had income over $2,829 a month, they were incapable of receiving Medicaid at home or in assisted living. But now we follow many of the other states, and we're allowed to use what's called a qualified income trust or a Miller trust. And the qualified income trust, what it says is that it's a little bit confusing to people to do on their own, because what it says is that any income source that puts you over the $2,829 a month must be placed in this qualified income trust. So it's not just the amount of money that puts you over the 2829, it's the income source. So for instance, if you have Social Security, $2,500 a month, and a pension of $700 a month, we would recommend putting the pension of $700 a month. So it's transferred, usually it's direct deposited into the Medicaid applicant's account. And then the power of attorney agent transfers it into the qualified income trust, which was created before the application was submitted. And then the qualified income trust has certain payment criteria. And there's an order that money can come out of the qualified income trust. It is to the spouse, we haven't discussed yet, in the event that the spouse is entitled to a monthly maintenance needs allowance, to health insurance for maybe a supplemental secondary policy, and then as a cost share to the facility. So now that I'm talking about this, it makes more sense what this individual was saying. Is there a cost share with a pool trust, because there's a cost share with the New Jersey Qualified Income Trust? It's just that that's one of the allowable expenses, and it's usually the largest expense because people are normally in assisted living or in a nursing home, and so all of your income minus the monthly maintenance needs allowance to the spouse and your health insurance premiums must go to the facility that you're in. So the next is when there's a married couple, and that's of course more complicated, but it opens up a lot more strategies for planning. And the way that it works when there's a spouse, again, the applicant can have no more than $2,000. And by the way, the $2,000 doesn't include exempt non-countable assets. So the home, so long as you're still living there or your spouse is living there, is an exempt asset. An irrevocable burial trust is an exempt asset. One automobile, if you're not living in a nursing home, is exempt, and these Medicaid compliant annuities, which we may or may not get to later, are exempt. But for the spouse can keep one half of the non-exempt assets up to $154,140. And anything over that must be spent down. And there are a number of different strategies to spend down a number of exempt assets that one can spend the money down on, or they can simply spend it down on their spouse's care until the spouse is eligible. The healthy spouse is also entitled to this monthly maintenance needs allowance. In New Jersey, The minimum monthly maintenance needs allowance is $2,555. The maximum is 3,300 and change. What does that mean? Well, it means that the healthy spouse, or the community spouse, as we call him or her, is entitled to income every month to continue living. However, the numbers I just gave you, we'll use the minimum number, $2,555, is the net income after the community spouse's income. So, for instance, if the community spouse, the spouse not applying for Medicaid, has $1,500 a month in income, they can take a minimum of about $1,000 from the Medicaid recipient, and a maximum of 3,300 minus their income. So I think I said 1,500, so 3,300 minus his or her income, and that's basically how it works. Um, the the home equity limit is 1,071,000. Is it the same in New York? I think it
A
might be.
million, yes.
Yeah, so it's a million. That's, I think, the federal number now. So it's 1,071,000 that you can exempt. So I have a question here: is there still a lien on the home? So that's a great question, and it's a mistake that a lot of people make when they don't hire a professional to do the work. When you have a married couple, very often they own the home as husband and wife. If, let's say, husband goes into a nursing facility, the house, yes, is still exempt. However, Medicaid, actually, the state of New Jersey actually, quote unquote, requires that you remove the home ownership from the Medicaid recipient's name within 6 months, but they don't really follow up on that. And so, if the Medicaid recipient, passes away, or when they pass away, the state of New Jersey will ask what was in their estate when they died. And if the house is still in their estate when they died, there will be a lien on the house. So we like to move the house over to the community spouses. We do it as a matter of course, so that there is not a lien. So, because it is not in the Medicaid recipient's state when the Medicaid recipient dies. We in New Jersey do not have spousal refusal, meaning that if the spouse, as I said before, has more than $154,000, the then the Medicaid applicant is not going to receive Medicaid. They will be what's known as over-resourced. And IRAs and 401ks are not exempt assets in New Jersey, so they are countable. What we recommend in my practice is that if somebody is entering a nursing facility or an assisted living facility with a high level of care, that they use the IRA assets first. And the reason for that is that many times they're taking the required minimum distributions anyway. But on top of that, if they need assistance with at least, I think it's 2 activities of daily living, then the entire assisted living facility bill, for instance, is considered a medical expense deduction, and they can take that against the deduction against the income from the IRA. So I recommend that they aggressively liquidate that IRA against medical expense deductions when that first happens. Any questions so far? Is the 6-month name removal of the recipient state of New York eliminating a lien? And I'm not 100% sure it's 6 months. I just know that they require that it be removed. We just do it anyway. Just good practice. But is there a 6-month
So,
limit?
no. So in New York, well, I don't know if I'm repeating exactly what you said, but in New York, if husband and wife own the property, we're transferring the ownership to the well spouse, let's say, before
Right.
we even submit the Medicaid application.
Right.
Because I've had Medicaid file an intent to place a lien on the home, even with the spouse living in there, or they've sent a letter that they will place a lien on the home. So we want to, when the applicant is still on a deed. So we want to transfer it beforehand anyway. So there's really no we don't deal with the 6 month or any time period of removal after the fact because we do it before we even file the application.
Same with us, right? We just do it as a matter of course. Okay,
Yeah.
so there are a couple of questions here. Okay, this is from Melissa. Are spousal refusal applications generally approved, and how long does the application process take in New York?
Okay, so the applications are there's no difference between approving with a spousal refusal or not. If the application is good, the spousal refusal is never going to stop it from being approved. It might be denied for some other reason, but it's never going to be denied for spousal refusal. The application process, that's an interesting question. It's really going to depend on the county. Every county works at their own pace. Every county makes some rules up as they go. They, look at the regulations differently and they act based on how they're reading the regulations. So it can be, something could be a battle in one county that's completely fine in another. And so depending on where you are and who your caseworker is, I mean, you could have something approved in 3 or 4 weeks. You could have something that takes a year to get approved.
And I'm glad you said that because that's what's going on in New Jersey as well. It's a county by county. So you always apply in the county in which you want to receive Medicaid, not the county in which you lived prior or where your spouse may live. And some counties, Bergen County, for instance, complies with our 40-day rule. So they almost always will give you an approval or denial within 45 days. But many other counties are 3 to 4 months. There's one county, which I won't disclose, which can take about a year. And then there are counties which are getting more and more frequent where it seems that the Medicaid caseworkers aren't all that well trained, and they give you pushback on things that that we never received pushback on before. And
Mm-hmm.
then when we take them to we have one county. I'm not going to get too deep into it, but the application was certainly wrongly denied. We took them to a fair hearing. The administrative law judge agreed with us, and then the county appealed, which surprisingly enough, a really silly decision. And so now we're in litigation, civil court over some ridiculous
Yep.
decision. Not really sure why. Almost seems like they're just being too proud. Okay, so here's a question. I thought that New Jersey has two different kinds of Medicaid, MLTSS and another level. You have to understand something about Medicaid. Medicaid is a huge monolithic program, but we're only talking today about long-term care Medicaid. And MLTSS is our long-term care Medicaid program. It's comprised of home, assisted living, and nursing home care. There are so many other programs that we really don't deal with. One of the things that I actually just wanted to revisit was Melissa said earlier that for the most part, assisted living facilities or communities in New York don't accept Medicaid. There are a couple, but they're not. It's not a big part of their Medicaid program. That is where I find New Jersey to be the strongest, and where a lot of times people, and one of the reasons we do this webinar is that we find oftentimes that families have uh, members of their family in New York and families in New Jersey. And so you may want to, in essence, forum shop sometimes for your loved one if they do need care. So in this case, New Jersey requires that any assisted living community built after 2001 must accept Medicaid in 10% of their beds. So what happens is that most assisted living communities in New Jersey accept Medicaid because of that, because most of them are newer, 2001 or newer. And they usually have either a 2 or 3 year private pay period. So it's not normally a guarantee, although some communities will guarantee a spot. What happens is after 2 years, you can qualify to get on their waiting list. And depending upon the community and the population there, that waiting list could be a month long, it could be a year long. But eventually you will receive Medicaid in that community. You'll receive the same care. The biggest difference is that the state of New Jersey will only pay for a shared room. They have specific Medicaid rooms, which also depending upon how the community is designed, some of them, when they say shared, aren't really, they really share a bathroom. That's really it. But they do allow the communities to accept supplement, meaning that the family can pay to keep the individual in the room that they were in prior to it. So it's really it's a great program for people in New Jersey, and we try to help people navigate that as much as possible because it seems to me that that is the sweet spot of where people want to be. Home is great for some people, but if you're social uh, and you want to be more active, you want to be in assisted living, and of course, a skilled nursing facility, a nursing home, is more institutional. So assisted living is great. Um, so this, I'm not sure who this is for, Dina. What if the person on Medicaid has an annuity that brings them over the income limit? Can the spouse use that money directly, or does it have to go into a pool trust? So I'm guessing it's for New York because we don't have pool trust.
Okay, I hate annuities.
Me too.
Okay, so here's the story with annuities. In New York, if you have an annuity that is an IRA annuity, it follows the IRA rules, which means it doesn't count as an asset. The required minimum distribution is part of the income, and it would work the same way as any other income with the pooled income trust. So that's going to be owned by the individuals. It's going to be owned by the Medicaid applicant. It has to follow their income, right? It doesn't go to the spouse unless, like I said earlier, the person in the nursing home is the one with the IRA annuity, it's kicking out income, and the spouse in the community can pull some of that income depending on how much they make on their own. If the annuity is a non-qualified annuity, so it is non-retirement money, I am typically advising the applicant to cash those in and or transfer the ownership to the spouse if there's a spouse, maybe, but not to keep it because it does count as an asset and it will make them ineligible. Then we have the third kind of annuity, which I just had this happen the other day. It's an annuity, it's non-qualified, it's annuitized. So it is kicking out income. It cannot be cashed in. And so it can count, the person can still qualify for Medicaid. They can keep that annuity. The income counts as income, but they have to name New York State as the beneficiary of the annuity. So there's really not much of a choice in that regard, other than to do that. And it doesn't come up all that often, believe it or not, but people are not happy when I tell them they have to do that. So it really depends on what kind of annuity we're talking about. And I'm sorry that none of these questions just have a yes or no answer, because that would just
Exactly.
be so much more pleasant for all of you.
So we went through the same scenario this year, but it was a TIAA CREF annuity, which in New York would have been okay because it would be what's called a qualified annuity. But yes, we couldn't, they wouldn't allow us to liquidate it, and we had to name the state of New Jersey as the first beneficiary, which is one of the qualification criteria to make an annuity Medicaid compliant. In New Jersey, like very similar to New York, if it's a non-qualified or it's a qualified, it is countable as an asset. So yes, you can transfer to the spouse, which transfers between spouses do not create a penalty, which is a number of days, weeks, or months that somebody's ineligible or not going to receive long-term care benefits. You cannot transfer these things to another person, like a child, for instance, that would create a penalty. So very often, either we recommend they liquidate it and spend it, or we can convert these annuities into this special product, which is beyond the scope of this presentation, called the Medicaid compliant annuity, which we're using more and more in New Jersey to allow people to get on Medicaid, either with annuities or with a lot more money than they would normally be able to keep. Well, in New York, can you prepay for funeral costs to reduce assets? Can you do this directly with a funeral home, or does it need to be done with a lawyer? for that
Yes,
one.
we do prepaid funeral. We recommend it all the time, especially for the Medicaid spend down. It's a legitimate expense for Medicaid purposes. You do it directly with the funeral home. And we've also had people, so it has to be irrevocable in order for it to work for Medicaid. Otherwise, it's available because you can undo it and take the money back. But you can also prepay for immediate family members. So if there is like that kind of, you're in that funny spot with how much money you have, like it's over the 31,175, but it's not quite enough over to do any other sort of planning. Sometimes we'll have pre-plans done for the children or something. We'll recommend that as another way of reducing assets. But there's no concerns as long as they're irrevocable. And if you make a mistake and they're not irrevocable, they're very easy to change over to irrevocable.
Right. And the funeral homes are very familiar with this.
Yeah.
Yeah. In New York, should a married couple set up one pool trust or two, one in each name?
So that's a good question. If I'm applying for both the husband and wife or both spouses together, they are allowed to have $2,351 in total income. It's easier, I feel, to set up one pooled income trust. But the actual nonprofits that run the pooled income trust sometimes have different opinions on that. So, you know, I try to stick with the ones who will allow one because I think it's easier to manage for the family. But sometimes they require that you do two.
Right. For assisted living, this is New Jersey. Assisted living, is the facility required to offer the supplement to a private unit? No. So the facility is just allowed to offer a supplement. And my understanding is that the supplement is the difference between what Medicaid pays and what the room would cost without a level of care. So it's very often $1,500 to $2,000 a month, but they do not have to accept the supplement. Um, it's not a requirement. This person, is saying it also is a TIAA annuity. So you were saying beneficiary is New Jersey, or we spend it down or try to convert it, right? I couldn't possibly answer that question without looking at the totality of the fact. There's no way I could answer that question. Question two for New Jersey, again for assisted living. What guidance can you offer for residents living in assisted living, completing their spend down, and then waiting for Medicaid approval? I'm specifically wondering about family paying privately until Medicaid approves or denies. Okay. One of my mantras is do not apply for Medicaid. Do not wait until you're impoverished to apply for Medicaid. Now, it sounds counterintuitive because you have to be impoverished in order to apply for Medicaid. But what I'm saying is that there are strategies to be able to force impoverishment in order to apply for Medicaid earlier, just so you can keep some money on the side. Now, New Jersey, because we are unique in the fact that most assisted living communities accept Medicaid, we the rules are very gray regarding payment of the assisted living fee while the Medicaid application is pending. And it didn't used to be gray, but it became gray this year. So in a nursing home, and Melissa, correct me if I'm wrong, if in New York, I think it's the same. When a Medicaid application is pending, the only thing you're required to do is pay your income to the
Correct.
nursing home.
Mhm.
But assisted living facilities are governed by New Jersey law, not federal law. So in New Jersey, most assisted living communities require that, and it says it in their agreement when you enroll your loved one, that the family is required to continue to pay while the Medicaid application is pending. Now, this I've always found to be really an onerous requirement, because when your loved one runs out of money, now all of a sudden the family has to come out of pocket and lay out the money. And as we were saying, yes, it could be 45 days. The application period could be 45 days, but it could be a year. And you don't know if your loved one's even going to be approved during that year period, because the caseworkers aren't always very communicative. So you're laying out all this money. But here's the draconian thing that's been happening in New Jersey. started happening at the beginning of this year. What we're finding is, I've notified my clients who are pending Medicaid, and I hope I'm wrong because it's only happened in a couple of counties, but I have a feeling it's going to happen all over. What what the Medicaid offices are saying now is, well, since somebody paid for the community during the pendency of the application, we're not going back to the eligibility date. We're only going back to the last to the month that hasn't been paid for yet. So let's
Yikes.
say, yeah. So let's say you paid for, and the communities are telling the families, don't worry, we're holding this on the side. You're going to get it all back, and then they realize they're not being reimbursed by Medicaid. They're saying, I'm sorry. So it's costing the families a lot of money, and they're surprised that this is happening. So the only thing that we can do is advise our families try not to pay during Medicaid pendency period. However, you're going to get a 30-day notice of eviction because your loved one may become a non-payment. So you have to talk to them when the time comes. Um, Nothing is written, at least that I've seen. Nothing is written about this. We're just seeing some counties doing it, and I don't even think that they're doing it all the time. So it may not even be a consistent rule. So we just have to be really careful when it comes to that. Very difficult thing for people
Hmm.
to navigate. And by the way, another reason why planning is so important. If we can plan 5 years in advance, we can set some money aside so that the family can feel secure that they can pay during this time period, whether it's the pendency of the Medicaid application or the being on the waiting list for a Medicaid slot in that facility. At least they have money on the side rather than waiting for their loved one to become impoverished and then having to figure out how they're going to pay for their care.
Hmm.
Okay, if someone is on Medicaid in one state, okay, I know this is going to be a good question, and has to move to the other state, how long does the transfer take uh, if they're eligible in both states? Or how long could someone be without Medicaid coverage until approved? Okay, you want
Sure. I mean, there's
to,
really no transfer.
right.
It's, you're leaving the state, like you're leaving New York, you're going off of New York Medicaid, you're going to New Jersey, and you're starting the application process there. So it's however long the application process is in either state, again, depending on your county and everything else, how long that is actually going to take. Um, so yes, that person would be without coverage during that period of time.
Now, in New Jersey, it depends on where you're going to receive Medicaid. So everything Melissa said is correct, except in if you're going into a nursing facility in New Jersey, as I said before, the nursing home is required required only to accept income. And so if you are otherwise eligible, if you move from New York, for instance, or Florida, whatever, to New Jersey, and you're impoverished and you're clinically eligible, the eligibility will go back 3 months
Hmm.
prior
Same
to
in New
the
York.
date.
Right.
Yeah, same. Yeah. So you won't be without coverage so long as you're approved. However, if you're in, first of all, assisted living is not going to accept you like that because there's a private pay period in our assisted living facilities. And home-based Medicaid, it if you're moving, let's say, in with a child, an adult child, there you're not covered for home care, even though you're otherwise eligible 3 months prior, because they're not going to start paying an agency until you're approved. So the
Right.
only time that it's a seamless transfer where there's probably no money out of pocket would be in it. That's a great question. It's a question we have all the time. Intuitively, people you would think, well, I'm on Medicaid in one state, I should just be able to transfer, but it doesn't work.
And the next
Uh,
question's a good follow-up to that.
okay, yeah. Is there any specific amount of time that a person has to live in either state to establish residence?
Not here in New
Not
York.
yeah, not New Jersey. As soon as you're they're just looking to make sure that you live here and that they have someone to pay. So if
Right.
you're living in your child's home, um, they're going to pay the agency that is visiting you. If you're living in a nursing facility, they're going to live it. But they do have to be you do have to be what they call passed in New Jersey. I don't know what they call it in New York, but PAS, a pass nurse, a county nurse comes out to evaluate you first, and that's how the whole process begins.
Yeah, we have the, it's called, NYIA, it's New York Independent Assessment.
Okay, and now let's just discuss because I don't see any questions, and feel free to ask more. Well, there's one more question, but Melissa, tell if you can remember, you and I had an email exchange last year about somebody who it's a married couple. Wife lives in New Jersey, children live in New York, and she wanted her husband to get home care in New York, but she was going to stay in New Jersey.
Right. So
That's a
the
no-no,
issue,
right?
yeah, that the issue with that, I believe, if I remember correctly, had to do with spousal refusal. So she
Right,
wanted to
right.
stay in
That's what it
New
was.
Jersey and sign spousal refusal as to her husband who was in New York, and he can't do that. She also would have to be here in New York in order to take advantage of that exemption.
And is there some sort of proof of residency for her, or does she have to show that she physically? How does she prove that she lives in New York?
I mean, so, still having ties in New Jersey is tough. I mean, obviously, if they're gonna sell a house, it's gonna take time and things like that, but they need to show that their residence is changed to New York, whether it's the driver's license, where they're filing tax returns, where their mail is going, that kind of thing.
Okay. So this question, which I missed before, is the Board of Social Services in New Jersey the entity that decides how much spousal allowance is? Yeah, they do, but there's a formula, and they take into account rent or mortgage payments, utilities, food, and things like that. Uh, there is a minimum, although I will admit, since I don't get into the weeds with the Medicaid application, we have seen people get less than the minimum, and there's always exceptions to everything. But it's very rare. And the minimum again is at $2,555. And then there's is the maximum, which you can go up to by showing that you have all these other payments, rent or mortgage or utilities. Um, okay, if a person is on SSI, which is supplemental security income, that's normally for individuals who haven't worked 40 quarters. I'm not an expert in SSI, but I believe that you automatically get Medicaid, right? When you qualify for SSI.
Correct.
So if a person is on SSI in one state, then they would be able to seamlessly transfer their Medicaid to any other state, as SSI is a federal program. Is that still correct? Sure. Do you know,
I'm not
Melissa?
really sure either, but I would imagine that it wouldn't just seamlessly transfer. They would still be eligible because they're on SSI, but they would still have to file their paperwork in that state and get approval through that
Yeah,
state, because there's no other way to really get a Medicaid approval. There's no federal, approval.
right. I think that they would still be on SSI.
Oh, yeah. Yes, yes,
Right.
yes.
Yeah. So my understanding of SSI is that it is such a small income that most people are on SSI merely to receive Medicaid,
Hmm.
their health insurance and things like that. So right. So Melissa, I think you're right. The SSI stays, but you'd have to reapply for the Medicaid. Uh, can you prepay for funeral home to reduce assets after becoming eligible for Medicaid? Well, you wouldn't. Well, that's only if you, for instance, received an inheritance or a lawsuit settlement. So once you're eligible for Medicaid, you are impoverished. In essence, you're under that asset limit. You wouldn't need to prepay for the funeral. In New York, because you're allowed to keep more assets. I guess you could
You could,
if you
sure.
really wanted to. I don't think I would recommend it because it's always good to have more money than less. Um, so yeah, so there are a bunch of different strategies that we employ when somebody inherits uh, money. Sometimes sometimes they don't realize they're going to inherit money. It's like a uncle died or something, and you didn't really think that you were going to be part of the will. And then they call us, and we try to figure out the best way to keep them on Medicaid. In New Jersey, you have a couple of choices. You could either, if you're on Medicaid long enough, you could just pay them back and stay on Medicaid, or you can come off Medicaid and spend down the money, or you can find somebody who understands how the strategies work and do something else like prepay a burial, or buy a Medicaid compliant annuity thing, or gift it, or things like that, depending upon where you are.
Right. And similarly with New York, promissory note plan, where we get gift a portion of the money, loan a portion of the money, pay back the loan, and still be able to hold on to half of whatever that person has inherited. Just as an example of one of the strategies, but depends on how much money we're talking about and how far in we are to, being on Medicaid.
Uh, this is the last question we have, and then there's something I want to talk about regarding ancillary things that, or very important things that elder law attorneys do, rather than just the Medicaid component when we have people who are filing for Medicaid. If we build an ADU for future living on my daughter's property in New Jersey, and one of us needs home care in New Jersey in the next 5 years, will the money going to the building project count in the look back? It depends on how long you live there. I very rarely see this, although I do get questions, what if, but it never seems to come to fruition. I think, and I could be wrong, but there's a limit. I think it might be 3 years. You have to live there for a period of time, because they want to obviously prevent people from just giving their children money to build onto a home that they never actually occupy. So it might be 3 years. I could look up the rule, but it can be done. And the thing is, when I look at Medicaid, and when I look at these questions, I try to be as conservative as possible when I'm planning for people, because, as I said before, you're not just dealing with the law. You're dealing with individuals who are not educated in the law. They're quote unquote trained. I don't really. I sometimes wonder what kind of training they receive, but a lot of times we think that they're just trained to try to deny application. And so I want there to be as few issues as possible when when our clients are applying for Medicaid, because the simpler the application, the better off we're going to be, the better result we're going to get. So the one thing I wanted to discuss is, we're talking about all these complicated issues when it comes to Medicaid, but there are some very easy things that people can do to make their lives easier. So, for instance, if you or your loved one is uh, is elderly, or you're near a Medicaid application, or potentially on Medicaid already, your estate planning documents certainly need to reflect that fact. And what we see when people come to our offices, whether it's New York or New Jersey, they very often have these "I love you" wills where they leave their estates to one another, and to husband to spouses. That's of course that's common. That's because you love your spouse, or you've been with your spouse for many years, and you leave it to your spouse when your spouse dies, it goes to your children. But if your spouse is on Medicaid, or elderly, or preparing for Medicaid, and now let's assume that in New Jersey, your spouse is on Medicaid, and you have the house, and the house is an exempt asset, and this $154,000. Well, if you pass away before the Medicaid spouse, and you haven't changed your will, all of that is going to the spouse, which is now jeopardizing a legacy for your children, and undoing everything that we've already done. So it's always important as we age to review our estate planning documents. Same thing with powers of attorney, financial powers of attorney, healthcare powers of attorney, all of that, because very often our spouse is the first agent. And I'm actually surprised at how often I saw one today, these documents. Okay, so people have signed them, great, but they don't have a successor. For some reason, the drafting attorney didn't recommend having somebody else in the event the spouse can't act. And even if they do have a successor, now the successor has to prove that the primary couldn't act, and that just holds things up. So all these things should be reviewed as we age. Unless you want to weigh in on that.
Yeah, I mean, I agree 100%. We always want to make sure that, and it's not always the easiest conversation, but we want to make sure that the well spouse is doing as much as possible to protect from the money going back to the spouse that's on Medicaid. Can't completely disinherit them. Here in New York, they'll have the right to their elective share, but there are other things that we can do to plan for the spouse. And yeah, I mean, I just met with people this morning who had the same thing. They named each other as the agent, and there was no backup at all. And they had 3 kids, so it was never discussed. And they had a title company logo on the top of the power of attorney. So I know that it was likely not done even with an attorney necessarily. So it's important, even with those basic documents that people can, do anywhere, that they're doing it with attorneys who know how it's going to kind of pan out as you move forward with anything related to elder law. And I just want to touch on the apartment question in New York that you were talking about, building on to the child's house. So we have a very interesting rule here. So as long as the money is paid directly from the parent to the contractors and not actually to the children, and the structure that's being built is solely for the use of the parent or parents, they will not count it as a gift or a transfer. So in other words, I've had cases where mom and dad have moved in, they've like gutted the garage, let's say, to make it into an apartment, and then they built a deck off the back with a ramp for a wheelchair. Medicaid will allow everything except the deck because the deck can be used by everybody. So it's that type of kind of scenario. And I'm doing this for my parents right now. That's why I'm very familiar with the whole thing. But yeah, it's that's a tricky one sometimes.
Yeah. And in our final minute, Melissa did touch on the elective share, which is something we probably won't, and we only have a minute. But the elective share is important because if you disinherit your spouse, so if you think, oh, I'm not going to go to an elder law attorney, I'm just going to go to my, the local attorney and tell him I want to disinherit my spouse, it can potentially create problems down the road because there's something known as the elective share. In New Jersey, the surviving spouse is allowed to elect, entitled to elect to keep 1/3 of the entire estate, the estate of both spouses. And if it's not available to them, then Medicaid we'll call it a transfer, and there will be a penalty for it. So it's important to get good advice, put it that way.
Mm-hmm.
All right. And anything you want to say in summary, Melissa?
I don't think so. I mean, thank you for joining us again. We'll certainly do this again. So if you have any questions that you think of in the interim, write them down. And our information is up on the screen to contact us via email or phone, and our website. So feel free to reach out.
Yep. And thank you for your participation. This is great. And thank you, Melissa.
Thank you, Eric. Good to see you.
Bye, everyone.